All rise.
Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon, everyone, in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is KSC BC 2020-06. The Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Salimi, and Jakub Krasniqi.
Thank you very much, Madam Court Officer. Now I will kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor, please.
Good afternoon, Your Honor, and to everyone joining. For the Specialist Prosecutor's Office this afternoon are Alan Teager, Senior Prosecutor, Matthew Halling, Prosecutor, and I am Claire Lawson, Senior Prosecutor. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense, starting with Mr. Kihu, please.
Good afternoon, Your Honor. Gregory Kehoe, Luka Misicic, Dostid Palaska, Sophie Menegon, Bonnie Johnson, and my colleague Jonathan Greenblatt is on the video in the lower left there, all on behalf of President Hashim Thaci. Thank you.
Thank you, Mr. Kihu. Mr. Emerson, please.
Good afternoon, Your Honour, and to those following inside and outside the courtroom. In court today are Annie O'Reilly, counsel, Pascal Longley, the legal associate, Samir Salih, a legal associate, Haradin Kuchi, legal advisor, and Tess Hughes, who is supporting the Vasili defence team, and I am Ben Emerson.
Thank you, Mr. Emerson. Mr. Young, please. Microphone, please.
Is that better?
Definitely.
Thank you. So David Young representing Mr. Recep Salimi, and today I'm assisted by Mr. Jeffrey Roberts, co-counsel, Dr. Rudina Yassini, co-counsel, and Natalie Rychenko and Riva Getchai. Thank you very much.
Thank you, Mr. Young. And now I turn to Ms. Alagendra, please.
Your Honor, Venkateshwari Alagendra, and in the courtroom is Mr. Aidan Ellis, Mr. Victor Baisu, and Mento Bichiri, and joining us online is also Dato Fauzia Momatai.
Thank you, Ms. Alagendra. For the record, I note that Mr. Thaci, Mr. Veseli, Mr. Selimi, and Mr. Krasniqi attend this hearing via video conference. And now, let me see. I think that the counsel for victims, Mr. Laws, is not currently attending the hearing. Let me ask, Madam Court Officer, can you confirm that he's not attending, and can you give an update on the situation of the connection, if there is any problem, please? Thank you. So the court officer informs me that there has been some difficulties to establish a connection with Mr. Laws, and that the connection is trying to being established. And I see that Mr. Laws appear on screen as I speak. So I am told that Mr. Laws is trying to connect. The connection is still not properly established, but he apparently can hear us on the phone at least. So I will ask Madam Court Officer to give an update as soon as you have more information. Now I turn to the registry. Mr. Nielsen, please.
Good afternoon, Your Honor. Good afternoon, colleagues. Jonas Nilsson, Judicial Services Division Registry.
Thank you, Mr. Nielsen. And for the record, I'm Nicholas Guillou, pretrial judge for this case. On 15 March 2022, I scheduled this 11th status conference. I asked the parties to provide written submissions if they so wished. On 22 March 2022, the SPO and two defense teams provided their written observations. I thank these parties for their submissions. The purpose of our hearing today is to review the status of the case and to discuss the topics in our agenda, specifically disclosure, translations, SPO investigations, defense investigations, and proposals for streamlining the case. I will invite the parties to present their views in a concise fashion about each item. And let us now move to the first topic that was listed in the scheduling order, which is disclosure. I will give the floor to the parties on the disclosure of each category of evidentiary material separately, as I did in previous status conferences. First, the evidentiary material emanating from other proceedings. Second, the Rule 103 material, which is material relevant to the case as listed by the SPO. Third, Rule 103 material, which is exculpatory material. And finally, the Rule 107 material, which is protected material for which the consent of the provider is requested. Let us start with disclosure of evidentiary material emanating from other proceedings. In its written submissions, the SPO indicated that relevant additional materials emanating from other proceedings are being prepared for disclosure and/or notice in this case. The SPO specified that the majority of such materials require extensive redactions and related protective measures in order to make them available in this case, and that protective measures filing will be submitted. I would like the SPO to give a timeline for these protective measures requests and to confirm that no other Rule 102.1 material is to be disclosed to the defense. And before I give you the floor, Madam Prosecutor, I will just have an update on Mr. Laws. I see that Mr. Laws have now joined. Mr. Laws, can you hear me?
Your Honor, I can. Good afternoon, Your Honor, to everyone. I'm very sorry for keeping the court waiting. There was a technical issue, but I've had great assistance from the AV booth, and I'm now with you. Thank you.
Thank you, Mr. Laws. And I was just going to give the floor to the SPO for their for the first topic on the agenda. Madam Prosecutor, please.
Thank you, Your Honour. We have nothing to add to our written submissions in respect of the material from other cases. You summarised it correctly, and we will be preparing that filing. We would anticipate to be able to make it in the first half of April. With respect to Rule 102.1b material, we can confirm to the court that the small number of items for which an extension request had been granted have now been disclosed in package 201. We would anticipate some further 102.1 disclosures, and we're aware that we will have to justify them and they will be subject to scrutiny in accordance with Your Honour's decision. What I can specifically mention now is we have identified an audio recording of very poor quality which appears to correlate to a written statement which has already been disclosed. And we have also identified a handwritten note of an interaction with a witness which provides additional detail to the information that has again already been disclosed. So we do anticipate a couple of items. Those are the two that I can identify for the court right now. We will make a relevant application and we're aware it will be subject to scrutiny. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Yes, Your Honor. Thank you. As with all of these matters, timing, of course, is crucial. We want to move ahead with this, as the court does and the parties the defendants, the accused do. My understanding with regard to the deadline for the disclosure subject to third-party approval was the court ordered by 31 March. If I'm not mistaken, that's next week. And I asked the court if the SPO is in fact going to make that deadline of the 31st of March, and any other information emanating from other proceedings, if we can get a more definitive time as to when that would happen. They said the first half of April. That's obviously 3 weeks. Is that the outside, or is that, as often is the case here, is that going to slip as well? Suffice it to say, we're just looking for a little bit more definition here as we move forward so we can know how to operate.
Thank you, Mr. Kihu. Mr. Emerson, please.
Your Honor, Ms. O'Reilly will deal with the disclosure issues, but may I just mention one thing? I don't know whether it's reached Your Honour's notice yet or not, but Mr. Vasili has to leave the status conference partway through because he has a pre-scheduled call with his children. I just raised that to notify Your Honour and ensure there's no concerns about that. And may I then hand over to Ms. O'Reilly to deal with the disclosure issues.
Thank you, Mr. Emerson. There is no problem on my side at all. I think there's been communication with the court management unit because a specific waiver needs to be signed for the second part when Mr. Vesely will not be here, because the waiver that has been transmitted is for the remote attendance. So this has to be arranged by DMU within the next hour, but I'm sure it's not a problem at all. And
Okay,
thank you, Mr.
very
Emerson,
much.
for indicating this today. Ms. O'Reilly, on the disclosure of the first category of material.
Yes, Your Honour. My only request is that you set a deadline. As the SPO has indicated, they believe they will be ready to file that submission by mid-April. So in order that there isn't any more slippage, I would invite you just to order that they file by mid-April. As regards to the additional items, I think Ms. Lawson mentioned 2, so I would just like clarification that that is all we're looking at right now in terms of further submissions, as that wasn't entirely clear. Thank you.
Thank you, Ms. O'Reilly. Mr. Young, please.
I would endorse the submission just made by the Vasili team that there should be a deadline for the material disclosure from the other proceedings. So I'm sure, as you're aware, Your Honour, that I think at least 12 of the witnesses in the other proceedings are also witnesses in this case. So for good case management reasons, we do ask that Your Honour set a deadline.
Thank you, Mr. Young. Ms. Alexandra, no, Mr. Ellis, please.
Your Honour, I'm afraid it's going to be me on most of the issues today. We've got very little to add on this point, though, save to note that, of course, 12 witnesses from the other case, and most of them finished giving evidence some time ago. So we would see no need for this to be pushed significantly further back, and we endorse the request for a deadline.
Thank you, Mr. Ellis. Madam Prosecutor, do you want to respond, and can you confirm that the request will be filed in the first weeks of April for protective measures, if any? And can you give more detail about the timeline for the disclosure of the documents?
Thank you, Your Honour. With respect to the questions raised by the defence, I believe I already addressed them in my initial submissions. The items for which the extension were granted have already been disclosed in Disclosure Package 201. And in response to Your Honour's question, I indicated the anticipated timeline for the application that needs to be made. I confirm that we do anticipate making it in the first half of April. With respect to the other items I identified, yes, an application is being prepared as we speak. Thank you, Your Honour.
Thank you, Madam Prosecutor. Let us now move to the Rule 102.3 material. Remember the parties that at the status conference held on 29 October 2021, I suspended the remaining defense deadlines for Rule 102.3 material. Since the last status conference, the SPO indicated that it has disclosed a further 7 packages of Rule 1023 material, comprising 5,298 items, but the number is actually higher now given the recent disclosure packages filed in the past 3 days, I believe. The SPO also indicated it will continue to provide the defense with spreadsheets upon the completion of the processing of individual Rule 1023 requests, including the item numbers. However, according to the SPO, the number of Rule 1023 items disclosed over the past 7 weeks have been lower than forecasted. Indeed, according to the defense, only a minority of the items requested have been disclosed so far, which hampers defense investigations. The defense also indicated that it is not in a position to determine how many items from the Rule 1023 notice have been disclosed overall, because the SPO has recently disclosed a number of items under Rule 103 that were requested under Rule 1023, but failed to link these items to the items listed on the Rule 1023 notice. The defense requests the SPO to provide a realistic estimate of the time that it will take for the SPO to complete disclosure of all pending Rule 1023 requests. And finally, the SPO considers that the reimposition of deadlines for Rule 1023 requests and responses would not serve to advance the process at this time. However, the defense submits that stricter deadlines for Rule 1023 disclosure must be imposed on the SPO so as not to further impede the defense preparation for trial. And finally, the defense does not support the reinstatement of deadlines for their own Rule 1023 requests. Madam Prosecutor, on this category of evidentiary material, you have the floor.
Thank you, Your Honour. As you noted, the numbers have changed somewhat since our written submissions. As it currently stands, since the last status conference, we have disclosed 19 packages of Rule 1023 material containing 8,284 items. In addition, we filed 3 protective measures requests relating to a Rule 1023 request from the Krasniqi defence and to 3 of the Vaseli defence Rule 1023 requests. And we have engaged in inter partes discussions on materiality with both of those defence teams, which have resolved many issues. And we thank them for that. In particular, in respect of the requests which we had committed to completing at the last status conference, I can confirm that the Krasniqi request from the 7th of October and the Vaseli request from the 16th of October have both now been fully addressed, save only for the pending protective measures requests, and with respect to the Krasniqi defence, the small number of items where materiality is still in discussion. In terms of the 25 Rule 1023 requests that had been received up to the date of the last status conference, 12 of those have now been essentially completed, and a further 3 are more than 75% complete. And specifically, we would anticipate completing 2 further Vaseli defence requests, the 2 which were part of the recent protective measures motion, within approximately the next 3 weeks. For the requests that are complete, we will be providing the relevant defence teams with consolidated spreadsheets in relation to those requests. And with respect to the submissions made by the Vaseli defence on tracking where particular items might have been disclosed, especially under a different rule, this is information which we specifically include in the spreadsheets that we provide to facilitate tracking. Apart from the progress being made, we are continuing to receive new Defence Rule 1023 requests. I believe there have been 11 further requests since the last status conference. There was an additional one on the 18th of March, which we neglected to mention in our written submissions, and a further one was received from the Thaci defence within the last hour. Although there has been real progress made, including in the filing of the protective measures requests, we recognise, as we did in our written submissions, that Rule 1023 disclosures during this last period were less than we had internally forecast them to be. And we're monitoring progress on a constant basis and diagnosing and addressing issues in the process as soon as they arise. In this instance, as we mentioned in the submissions, the disclosure team was particularly impacted by COVID-related absences. There were actually 6 members out of the team out at various points of time due to illness of themselves or a close relative in the past number of weeks, which I might add is almost the entire team. So obviously it was an unusual and unfortunate confluence of circumstances. But as soon as the impact of that became apparent and resources allowed, we retrained other staff, members of the legal team, to compensate with the processing of packages. And those disclosed on Monday and Tuesday this week were a direct result of those corrective steps. So we're continuing to take necessary measures to ensure the pace of disclosures under Rule 1023. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Yes, Your Honor, thank you. Obviously, we have made several requests for 1023 material. We've requested, since our last status conference before Your Honor, 1,000 documents. To date, we have received none of those requests. None of those requests have been met. Obviously, based on what my colleagues have written as well in response to their request, it is taking a significant period of time to get these requests answered in some fashion. We have no doubt, as our investigation continues, that we'll be submitting more requests for documents, which is, of course, the logical, the logical sequence of being out there and conducting an investigation. But given the fact that we want to move this case ahead, we are very concerned with the delays inherent in providing that information to us. We don't know if that information is just going to satisfy us at that point, or it's going to take us off in another direction. And our requests are not being done without thought among the entire team about what we really want. We're not asking for documents for the sake of asking for documents. That gets nobody, that doesn't get anybody anywhere, as Your Honor knows. So we are very concerned about that. We would like to see if the court can, put some guidelines in for the SPO as to when those 1023 matters are going to be met. As far as our obligations under 1023, any deadline, it's impossible to say, and that should be left open at this point. There is significant amount of witnesses, over 100 witnesses, well, we didn't even know who those individuals are. There are names being redacted, locations being redacted. There's redactions in, of course, Your Honor has seen the indictment, how that's been redacted. And once we get that information, is that going to bring about yet more 1023 requests? I have to believe, as I stand here as an officer of the court, Your Honor, that it will. So, well, I appreciate that there are some difficulties that the SPO has raised. There are likewise the continuous difficulty on the defense side, who we collectively want to move this case along because of no other reason. Our clients remain in custody while this case is pending. So any guidelines, strict guidelines that Your Honor can give to move this case along and ensure that we're getting those 1023 requests responded to in a timely manner is something that we would ask the court to do. Thank you.
Thank you, Mr. Kihu. Mr. Rayleigh, please.
Thank you, Your Honor. I'll quickly go over the statistics as to where we're currently at. We have requested 1,019 items since the last status conference, bringing our total to 20,506. So as you can see, we are also not requesting everything. We are actually trying to target our requests right now. But that means going through the entirety of all the incidents in the indictment, which makes it rather cumbersome. The SBO has disclosed a further 1,695 items. So that brings their total of disclosure to 10,123 items, which is actually about 50% of what we've requested. So indeed, there is more progress being made, which we do appreciate. but we would estimate it would need to be about 2 or 3 times faster than it has been in the last period in order to be really useful to the defence. As regards the 1023 versus 103 issue, that's appreciated that the SBO is committed to disclosing those item numbers and fixing the cross-referencing matter, as I understand it. But the problem for us is that the indexes are coming months after the documents in many cases, which means for our case management purposes, it's chaotic and we can't keep on top of the information, and given the sheer deluge of information that is upon us, that's just not working. And I frankly don't understand why we couldn't get those item numbers along with disclosure. So I'm hoping, sorry, excuse me, I'm hoping that's something that the SBO might be able to address as to why it can't be done contemporaneously with the disclosure of documents. We'll go into this in more detail. My colleague, Mr. Strong, will likely address it, but it would really help if we were able to streamline the case now for the purposes of 1023 disclosure. It is actually a very time-consuming process trying to figure out what we need from that list. So the sooner that the case can be cut, the sooner we'll be able to complete our disclosure requests and get those documents and move this case forward to trial. The translations issue seems to have sort of fallen by the wayside recently. Essentially, our position is that the framework decision says that evidence will be provided in the working language of the court. The SBO maintains that such a duty does not exist and that they do not have English language summaries of any of the documents for which they haven't provided full translations. If that's the case, that's the case, but there is still a matter here that needs to be resolved, and I would propose to do that in writing. Thank you, Your Honour.
Thank you, Mr. O'Reilly. Mr. Young, please.
Your Honour, we do appreciate the frank acceptance by the prosecution of their forecasts being out. And we appreciate the difficulties that they mention in relation to staff absence and the like, referring to that relating to the staff absences since the date of the last status conference. However, Your Honour, what's more troubling is that the defence, the Salimi defence request was for 39,839 items, was made on the 1st of November last year. And the second one was made on the 7th of December for 12,957 items. So on the face of it, the largest amount that we requested was some 5 months ago. So with respect to the recent difficulties, there seems to be a rather bigger problem of a system failure because this amount of material is not being processed. And as far as I understand it, I am not aware of any challenge to the materiality of the documentation that we need, and we need it now.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, in my submission, the most basic information that we need in order to manage this process is to know an idea of how long it's going to take the prosecution to process the requests that have already been made. That was the submission word for word that I made at the last status conference 6 weeks ago. I wasn't successful on that occasion in persuading the prosecution to give an estimate in terms of time. The estimate we were given of 5,000 documents per week clearly hasn't been met to date. If the total over those weeks is some 8,000 only. Obviously, we appreciate the problems that have been encountered with COVID, and there'll be no specific criticism in relation to that from me. But Your Honour wants to move this case along. We see that from the agenda items. We clearly want to move this case along as well. And we've been progressing through the 1023 notice, making the requests that we want to make. And we've set out in the written submission that we anticipate 2 further requests, which we'll try to make before the next status conference. But this is the sticking point right here, Your Honour. We've got all these agenda items coming up about defence investigations. Can the defence file the pre-trial brief before the summer? But in my submission, the question is, can the prosecution disclose its documents? Can it give us those documents that are material to our preparation? When's that going to happen? We need an estimate. Looking at the documents we've got to date that have been requested, the prosecution must have an idea for when this is going to be capable of being provided to the defence. And then we can all take case management decisions from there. But at the moment, in my submission, many of the other agenda items are going to become moot because we need to know, are we talking about 2 months? Are we talking about 3 months? Are we talking about more than 3 months before disclosure is complete? And I would request, Your Honour, again, we did it in writing before the status conference. Your Honour picked it up in your summary earlier. So the prosecution are on notice that we're going to ask this. What's the estimate? When's this going to be done?
Thank you, Mr. Ellis. Let me go back to the prosecution. I would like you to respond to the defense submissions, and especially, I think, 3 points that I would like to have your input on. First, is it possible to disclose the item number along with disclosure of each package? I think this was Ms. O'Reilly who mentioned that, so as to have this information immediately, not a couple of weeks after, so as to facilitate the analysis of the evidence. The second point is also from Ms. O'Reilly, the translation of the Rule 123 material, and if you're also willing to resolve any issues via written submissions. And the third question, I will follow up on what has been said by, I think, several, if not all, defense teams, is would you be able to give a more precise timeline for the pending requests, either through a pace, which is basically the number of items per week, for example, or even, if it's possible, a timeline for the requests that are pending. Madam Prosecutor.
Thank you, Your Honour. I will turn to the Vasselli defence queries first. As I think I mentioned at the last status conference, the volume of disclosure packages going out and the multiple packages being worked on at the same time does make it very difficult for us to provide detailed additional information with cross-references, item numbers, etc. for each package. It's information that we would have to collate or in some cases manually input. We saw that the Vasselli defence proposed a possible technical solution as well for tracking during inter partes correspondence. We're looking into that to see what is possible. As for including the item number specifically, it's a technical question that I'll need to receive input on, and we will come back to the Vasselli defence on it after this hearing. But obviously, the more work that we do accompanying each separate package, that's going to impact the pace of the packages overall. As for translations, if there's anything further to be discussed inter partes, we're happy to do that, and otherwise, if there's a filing, we will obviously respond to the filing. For the Salimi defence, they're referring to a request made in November which amounted to 40,000 items. Clearly that's almost 2/3 of the entire list which was requested in one go. So I don't think it would be a surprise that we haven't completed that request. However, we are working on it. They did subsequently prioritise certain items which they wanted to receive, and we appreciate them doing that. Approximately 400 of the items they prioritised hadn't been part of their original request, but we are nonetheless working on the request, and specifically on the prioritised items, over one third of which have already been disclosed, and a substantial number of the others are at an advanced stage of processing. In relation to timelines and estimates, as I mentioned, since the last status conference, we've received 11 further requests. You'll have seen, for example, that the request received from the Krasniqi defence within the past 2 weeks is almost double the size of any previous request they've made, and additional requests have been forecast. each request can be very significantly different in terms of the review and processing time based on its size, the length of the materials, the nature of the document sought, and of course any overlap, the degree of overlap, if any, with prior requests that have been made, which facilitates us processing it in an expedited manner. So with these fluctuations, it's really not possible for me to provide a meaningful estimate in terms of a date, but I can give an indication of pace. And in fact, although it may not have been reflected in the disclosure packages, we did maintain the pace of getting through approximately 5,000 items a week on average during this period. As I caveated last time already, this doesn't automatically translate into disclosures. First and foremost, because the vast majority of items actually require a second level review for redactions purposes, and we've learned from experience that that's an essential quality control. It's not something that we can dispense with. But equally, the packages themselves need to be generated, metadata checked, etc., which proved to be a blockage in the past number of weeks, but which we're taking steps to correct. So we hope to both catch the disclosures up with the reviews that have already been done and to maintain our review pace. Thank you.
Thank you, Madam Prosecutor. Let us now move to the Rule 103 material. Since
Excuse me.
Sorry, Mr. Reilly.
Your Honour, if I could just make two further submissions on 1
Sure.
and 2, 3. Sorry. First of all, with respect to the item numbers, I just wanted to clarify, we actually haven't received any item numbers going as far back as October, so it's actually 6 months, not a matter of weeks, 5 months. And that would actually be very helpful to us, and I understand Ms. Lawson's point that it would add time to preparing the disclosure batches, but we would be much happier to wait that additional week or however long and get those item numbers with the disclosure instead of getting them without any item numbers for 6 months. And a point that I forgot to make earlier, which is going back to the issue I raised at the last status conference about additional material that's coming into the SBO's possession and control. Our position is that also has to be reviewed to determine whether it's material and needs to be disclosed to the defence. I'm aware of any legal provision that would state otherwise, and so I would like clarification that that review is also ongoing to put additional items on the 1023 list. Thanks.
Thank you, Mr. Reilly. Madam Prosecutor, do you want to respond to that last point, please?
Yes, thank you, Your Honour. Items that have been received or cleared up to the 31st of January 2022 are in active review, both for 1023 notice purposes and for 103 exculpatory disclosure purposes. As I think we'll probably get to under the next agenda item, that's the reviews at an advanced stage. And once it's complete, we do intend to provide the defence with a supplementary notice in respect of residual items. Thank you.
Thank you, Madam Prosecutor. So since the last status conference, the SPO has disclosed 7 packages of potentially exculpatory items, and further packages are being prepared. And I think there is probably even more than that, because in the past days, I think there have also been at least one other package, if I'm not wrong. According to the SPO, with respect to materials received or cleared up to 31st January 2022, this review for exculpatory material is more than 70% complete, with approximately 2,500 items remaining to be assigned for exculpatory review. The SPO has also indicated that no further protective measures request for this category of material is imminent. The defense indicated that it does not understand why this material was not disclosed earlier, and that it has a direct impact on the preparation and investigations. In its submissions, the Krasniqi defense specifically requests that the SPO confirm that it has now disclosed all documents which state or suggest that the KLA did not have the command and control structures of a regular army, all documents which suggest which suggests that the situation in Kosovo after June 12, 1999 was chaotic or anarchic, and all documents which show that Mr. Krasniqi was outside Kosovo at any time during the indictment period, including during the period March-June 1999. The Vasily defense also requests that I set a timeline for completion of Rule 103 material within the next 30 days. I remind the parties, as I did multiple times, that exculpatory material must be disclosed according to the wording of the rules as soon as it is in the SPO's custody, control, or actual knowledge. So I specifically invite the SPO to indicate if it can commit to a deadline for completion of their review for exculpatory material. Madam Prosecutor.
The SPO is fulfilling its obligations in relation to Rule 103. We've been doing so in earnest from the very outset of proceedings, and we're conducting the review diligently and disclosing on a rolling basis. Since the last status conference, we've disclosed 8 additional packages of Rule 103 materials containing 751 items. As indicated in our written submissions, and as I also just mentioned a short time ago, with respect to material received or cleared up to the 31st of January 2022, we are over 70% through that review. There are approximately 2,500 items falling within that range, which remain to be reviewed for exculpatory content. And in light of the fact that this item-by-item review is nearing completion, we're simultaneously proceeding with targeted searches related, for example, to the witness list as a means of further ensuring that all potentially exculpatory items are identified and disclosed. Turning briefly to a couple of specific matters raised in defence filings in advance of this hearing, and as Your Honour mentioned during the introduction. In paragraph 13 of their filing, the Krasniqi defence referred to specific categories of items which you just enunciated. The defence had raised an inter partes query with us in relation to those categories at the end of last week, and we responded earlier this week on Tuesday. In the filing, we see that it's now framed as a request for confirmation that all items falling within those categories have been disclosed. But bearing in mind that, as Your Honour had directed at the last hearing, we did provide all defence teams with an inter partes update on the status and progress of Rule 103 review. And that update clearly indicated that there are items yet to be reviewed. I'm not sure it's a serious question because clearly it's not a confirmation that can be given until the review is complete. With respect to the request for a deadline, I was not intending to address that at length, and we submit that the Vasily defence should not be permitted to do so either. At the last hearing, Your Honour had directed that a request for disclosure remedies be submitted in writing in order to facilitate full briefing and decision-making. 2 of the defence teams, the Krasniqi defence and the Thaci defence, did so, and one of the remedies sought was a deadline, so there has been the opportunity for the Vasily defence to make any additional substantive submissions they wanted to make in relation to that request. But they chose not to do so and just filed a short joinder instead. It's unclear to us what the request in these submissions is intended to be, whether it's a supplement to that litigation or whether it's a separate request, but in either case it would appear to us to be inappropriate to now come a week after the filing was due, and to try to supplement shouldn't be permitted, and is also in contravention of the direction that the matter was to be briefed initially in writing. If it's intended as a independent parallel request, it's even more inappropriate to immediately attempt to relitigate the exact same issue again. I would say is bordering on an abusive process and would warrant summary dismissal. However, in terms of Your Honour's question as to when we will be finished. On the review side, in terms of the systematic item-by-item review of the collection that we've been conducting, we would anticipate that being largely complete by the time of the next status conference. Whether all items identified during that review will have been fully processed and disclosed isn't something I can confirm. However, in addition to the item-by-item review, I mentioned we're conducting targeted searches as an additional measure to ensure that material is identified and is disclosed. And we anticipate that further disclosures will be generated from those searches, but I'm not in a position today to give an estimate on that aspect of the review, noting that we receive potentially thousands of hits can be returned on a single name, and each of them would need to be looked at. But we remain happy to keep both the court and the defence apprised on progress. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Yes, Your Honor. I've noticed that the new catchword in many of the filings coming from the SPO is largely complete. I don't know what that means. Is it complete or not complete? We are talking about thousands of more exculpatory documents that, as Your Honor aptly pointed out, when it's in the custody, control, or actual knowledge of the SPO, custody and control, they're supposed to disclose it immediately. Not supposed to be, that means as soon as our clients were charged or came here in November of 2020, that process should have, if those documents are in their possession, should have happened immediately. Immediately. And Your Honor, it gave an admonition to the SPO. If it wasn't the last staff's conference, it was the one before that, about their failure to disclose the exculpatory 103 material promptly or immediately. And Your Honor insisted that it should be done immediately. I'm concerned on a variety of different levels that simply has not been done and continues not to be done. And it may very well be, and we'll go into that in a bit, on the rather myopic approach that the SPO has taken to the 103 material. The 103 material is not just exculpatory material, as Your Honor has pointed out in prior hearings, but it is, importantly, information that affects the credibility or reliability of the special prosecutor's evidence. Even if it doesn't mention these four gentlemen's names, it affects the credibility of the SPO's case, then it comes under Rule 103. We're not hearing that, and I can explain that in some detail. But let's just talk about the immediately aspect of things, Judge, of what immediately means and when things are being disclosed. Now, we received a 103 package at the end of February, which I'm grateful that we got. Ambassador Everart's notice information was in that package. I can't think of one, because certainly they knew it for a long time, and they elected not to turn it over to the detriment of our clients, and in fact, Judge, to the detriment of the court. Because as with much of this information, putting aside the trial, we have been advancing many arguments as to why our clients should be released, and much of that went to the frailty of the prosecutor's case, and they came back with any number of items concerning what would happen if these 4 gentlemen were actually released, completely unsubstantiated, etc. And again, the rhetorical question is, would not Your Honor want to know this exculpatory material when you're making a decision on pretrial release? Of course. Of course, the court always wants to be fully informed. There's no excuse for that. 16 months down the line since this interview was taken, well over a year and a half since our clients have been sitting in jail while this is pending, and we don't get this for 16 months after the fact? Is that the guideline that we are operating under for the SPO? That can't be what immediately means under the rule. It can't be. I submit to Your Honor. That's one aspect that is extremely troublesome on Rule the 103 analysis that is going on within the SPO, which in fact is one of the reasons why we've asked for this independent party to review the matter, but I understand that's sub judice, and that's for another time. The second issue. There were several hundred KLA witnesses that were apparently interviewed. 83 have been disclosed. Is there no Rule 103 material in any of those 100 other witnesses that were interviewed by the SPO? Because we haven't gotten it. We got the 83, but not the 100 plus that were interviewed on top of that. Now, I know some of them just elected not to testify, as was their right, but not all of them. Not all of them by a long shot. Where are those statements? Number one. And number two, is there no Rule 103 material in any of those? Any information that undercuts the credibility of the SPO's case? Of course there is. I mean, as we mentioned the last time, there are witnesses that still haven't been disclosed. Mr. Bukoshi, also, Avni Spahu, the former ambassador to the United States.
Your Honour, please, this is gratuitous mentioning of names of people who've been in contact with the SPO. We would request a redaction order. Thank you.
Mr. Spahu is not the witness for the prosecution. They don't have any ownership over this name. There's no protective measures for Mr. Bukoshi.
I think you don't need to mention names for the purpose of your demonstration for.
Your Honor,
I understand your point.
I will move ahead without the names.
Thank you.
Evidence that affects the credibility or reliability of the SPO's evidence. We've received no information on Serb false flag operations. For one instance is this Panda operation in December of 1998, where some Serb individuals were killed. It has come out with President Vučić of Serbia that was a false flag operation and was done, in fact, by Serbia. Does that undercut the SPO's case, especially in large part, is, number one, the SPO is dealing with the Serbian Secret Service for much of their evidence coming through, who, of course, were the author of this ridiculous organ harvesting allegation, which never made it to the indictment, but which came to Serbia via Russia, who, by the way, is doing the same thing in the Ukraine, but that's another story for another time. I mean, where is that evidence on false flag operations being conducted by the Serb intelligence service or anybody else within the Serbian government? Because that evidence clearly, Your Honor, would undercut the credibility of the SPO's case. Now, on this issue, and I hearken back to a comment by the SPO concerning their view of Rule 103 material. And if you recall, Your Honor, I presented or talked the last time about the letter coming from the United States State Department to the chairman of the Foreign Operations Committee of the United States Senate, where they said there was no political structure in Kosovo or effective command and control of the KLA. Their response is, oh, we've searched our files and that document isn't in there. Why not? They made any number of requests to the United States government for documents over the years. Over the years this has been going on. And they didn't make any requests for any documentation that affected the credibility of their investigation, because they say they didn't have this. And by the way, did anybody have knowledge about this when they went in and they were requesting documents from the United States? Did they know about the document and make a decision that they didn't want to take this document? That's a violation of Rule 103. And this is not the only document. There's a CIA report, January 3rd, 3 January 2000. CIA going publicly to the United States Congress on an appropriations bill. Clearly 103 material. The Central Intelligence Agency of the United States found that it says UCK, but the KLA leadership does not appear to have engaged in narcotics operations to support its activities during the war. That came from the Central Intelligence Agency. They also said the KLA was not involved in terrorist activities defined as premeditated, politically motivated violence perpetrated against non-combatant targets. That is at the very heart of the prosecution's case. Are they saying they didn't have this and didn't know about this report by the Central Intelligence Agency, where they said no traffic and and that the leadership was not involved in terrorist activity? Or are we taking again, a myopic view as to what 103 material is? I submit to Your Honor, it's the latter. And we have to broaden our horizons here and view as to what, in fact, is 103 material. And the test over there should be, if it hurts their case in any way, putting aside these 4 individuals, it should be turned over. That is a concern that, with all due respect, Your Honor, it needs to be remedied promptly, given the rule that this information should be turned over immediately and not in the case of a witness 16 months late. And I submit to Your Honor, we need Your Honor's assistance to ensure that that is done as quickly as possible, today, not when they decide in their rolling production to stand before this court and say, and I use this, largely complete. So, okay, largely complete means to be complete when? And as my colleague noted with regard to the 103 requests, all of this lack of disclosure has a trickle-down effect as to exactly what we can accomplish as we move forward with regard to our investigation, because we are significantly hampered in interviews, investigation, document requests from third parties, all of that information, with the dilatory nature in which this information is coming across to the defense. Your Honor, thank you very much on that score.
Thank you, Mr. Kihu. Mr.
Your
Ridley,
Honor,
please.
I'm sorry. On this one question, Your Honor,
Mr.
I omitted at the outset to introduce 2 of my colleagues who were joining remotely. One is Kwitim Kirveshi, who is the head of the investigation, and the other is Andrew Strong, who is the counsel advising on the investigation. Can I allow Mr. Strong to develop our submissions on the 103 material? I would echo the words that have been addressed to you by Mr. Kehoe. And you know, there are numerous strands of evidence which are available in the public domain, which confirm the sort of manipulation of evidence by the Serbian authorities, which included the exhuming of mass graves of victims of Serbian violence and their transport over the border into Serbia, where a lorry load was found in the bottom of the River Danube, and another very large number of bodies repositioned outside a police base inside the Serbian territory. So there was a, I mean, the evidence will show there was a very substantial cleanup operation conducted by Serbia, which involved manipulating evidence and again, it's open in the sense that it's been the subject of detailed evidence at trials at the ICTY. The Serbian RDB were using a wide variety of tactics to obtain false information, including torture, threats, and blackmail, all of which obviously is exculpatory material that ought to be part of the prosecution's analysis, given how much of its evidence has emerged from Serbian intelligence sources. I mean, this is in effect a case that largely depends on evidence that's previously been through the Serbian intelligence mincer. But with that said, as a general introduction, can I hand over to Mr. Strong to make our submissions on this aspect of the disclosure problem?
Thank you, Mr. Emerson. Mr. Strong, please.
Yes, thank you, Your Honor. We have requested a deadline now because at the last two status conferences, we invited the SBO to just provide their best estimate as to when we could expect Rule 103 disclosure to be complete. At the last status conference, Your Honor directed the SBO to answer that question. That's at T 896, line 3. They didn't do that. I still don't hear an estimate from the SBO as to when we can have that material in our possession. I hear that by the next status conference, some further part of their review process will be complete. But that, in terms of moving this case forward and allowing us access to the information that we can use to plan our defense, that's not helpful. What I understand the SBO's chief problem here is that this process is time consuming and it's complicated and it involves sifting through thousands of documents. And I am sympathetic to the volume of information because we're sifting through it as well. But it strikes me as an indicator, as another indicator, that this case is too large. That it's been 16 months that we've been in trial and that these men have been in prison. To be only 70% of the way done at this point suggests that something's wrong. I mean, the math works out there. If they've taken 16 months to go 70%, that's another 5 months to go the remaining 30%. And that's where we submit, Your Honor, that a deadline is needed. I think as a second point, there seems to be two different categories of evidence that I want to just flag. One are the existing databases that the SBO needs to search through. And I imagine these are large tranches of information inherited from AOLEX or from cooperating governments. That category of information needs to go through whatever process the SBO has designed. And we submit is probably too large, and that's why it's taking so long. But there's a second category, Your Honor, of information that the SBO has generated itself, right? Where there's an interview where the SBO is present in the room, and a witness has given exculpatory information. Now, for that category of information, it seems very straightforward to disclose that to the defense. And yet that's precisely the type of information that we've received in the last 6 weeks that has been taken 3 years ago. So for that category of information, I don't understand how it could take 3 years from having a prosecutor sitting in the room, elucidating exculpatory information, and for it to be turned over to the defense to give any meaning to the language in the framework decision that it must be turned over immediately. So for all of those reasons, Your Honor, we think that something is not working efficiently here to be at this point in the trial and still have this body of information to to be disclosed. As Your Honor has pointed out, this is critical information for the defense. It is the center target for us to form our defense strategy and our defense case. And so for those reasons, Your Honor, we submit the time is running and we need a deadline for this material.
Thank you, Mr.
Your Honor, can I just add one very small,
briefly, because I cannot have all the consulate team talking.
It'll take a second. I think the point that was being made by Mr. Kehoe and by Mr. Strong is that there are things which any prosecutor in this trial ought to have disclosed. And they're things that we can't help but know about because they've been disclosed and adduced in court in other proceedings. I give you one example. Evidence that the Serbian forces on the ground in Kosovo were issued with Chinese ammunition in order to make situations where they had killed civilians look as though they were committed by the KLA, which used Chinese ammunition, as opposed to the ammunition used by the Serbs. So there's no question that there were very serious attempts by the Serbs to implicate the KLA in crimes they didn't commit. And the question is, why has that evidence not been disclosed yet? And we have to hope that it's in the 30% that still remains to be disclosed, because as far as I know, it's not been disclosed yet. I mean, it couldn't be more obvious that type of thing ought to be being disclosed, because it goes directly to the indictment, and yet it hasn't made its way through. Now, is that because it's in the last 30%? We think highly unlikely, but possible. We think it betokens an approach to disclosure by the prosecution which is insufficiently rigorous, that none of this type of material has been disclosed voluntarily. It's a no-brainer and it doesn't involve redaction. So there's nothing that needs to be done, but it hasn't found its way through the system. So something is very seriously wrong. And obviously from our point of view, any question that you ask us about defense investigations, a pre-trial brief, trial dates and so forth, we have to wait and see what's in the 30%. And then we have to find out why it is they haven't disclosed the material that we already know about, which ought to have been disclosed. So, I mean, realistically, this cries out for a guillotine. We need to see, we need the prosecution to step up very quickly if we're to be talking about a trial beginning any time in the reasonably foreseeable future.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, as with our colleagues, we have grave concerns about the prosecution's disclosure position in relation to the exculpatory material. As Your Honour knows very well, this material goes to the innocence of the accused and has the ability to change the complexion of the entire case. With respect to what Mr. Lawson said for the prosecution, Your Honour, I think we need to analyse what the prosecution have argued or told you. At paragraph 8 of their written filings, they tell Your Honour that the review is more than 70% complete, with approximately 2,500 items remaining to be assigned for exculpatory review. Can we just explore a little what this means? Because my understanding, this appears to suggest that to date, they have made decisions, they have reviewed that material, this body of material, some 70% of the material, they've reviewed it, they've made a decision on it, it's exculpatory, so it has to be disclosed. So why not disclose it now? They appear to be saying, unless I've misread this completely, that although they have finalized their position on 70% of the material, it's exculpatory, so it's important for the defense. But we're not going to disclose it to you right now in flagrant breach of the rules, and the rules are there for a purpose. They seem to be saying, oh, well, we still have another 2,500 items. Therefore, we're going to delay disclosing what should be disclosed immediately until we go through the other 2,500. Now, if that is anywhere near correct, that's deeply, deeply troubling. And I do very much support what Mr. Kehoe said, particularly in relation to the body of KLA evidence, which appears to be undisclosed. Your Honour, if Mr. Kehoe's theory is correct, it would appear that there is a significant body of KLA evidence that's not been disclosed. And as Your Honour knows, it's often more telling in a trial, not what evidence is called, but sometimes what evidence is not being called. And so, with great respect, if this body of material does exist, in other words, 103 material from large body of KLA members, that is something that clearly ought to be disclosed immediately. As for other matters, of course, if new, I'm not suggesting at any stage there should be a cut-off point for 103 material, because it has to continue. But if they've got it now, they disclose it now. You should be disclosing it today. In the future, of course, if in further reviews they uncover new material and it comes into their custody and control in the future, then of course it can be disclosed later. But the point I think we're all making is there's no reason to postpone. And if you want to hold the prosecution to the rules of the procedure, there's only one answer. Thank you.
Thank you, Mr. Young. And I'll ask the SPO to answer your specific question about the paragraph 8 of their submissions, if there is a delay to disclose what has already been identified as exculpatory, waiting for the remaining 2,500 items. This is not how I interpreted their submissions, but I would like the SPO to confirm it. Mr. Ellis, please.
Yes. Your Honour, a few words from me about the issue of timings. And I do so knowing, of course, that there are written filings before Your Honour that Your Honour seized of and will deal with in due course. But we are, after all, at a status conference with Rule 103 fairly and squarely on the agenda. It's an issue properly before you today, Your Honour, as well. The prosecution says they've disclosed some 750 items in the last month, 8 disclosure packages pursuant to Rule 103. That's not evidence of a prosecution diligently performing its duties when we're 16 months into the process. The fact that so much material, 8 packages, is coming in the last month is a problem, not a sign of a system that is working. And then when we look at what is still to come, we're told that the item-by-item searches the prosecution hopes to complete by the next status conference. Well, that's proposed, I think, for the 16th of May, which is another 7 weeks away, Your Honour. So that in itself is quite a chunk of time to be waiting for exculpatory material. We've then got the targeted searches, which were introduced in the written submissions and I think orally today. What exactly are these targeted searches? Why haven't they been done previously? And how long are we going to be waiting for those? And that then needs to be fed in also when considering timings. We've spoken already today about the Rule 102.3 process. If we're looking at 5,000 documents being processed a week for that, well, there are 40,000 documents outstanding to the Krasniqi defence alone. So that's, 8 weeks if the prosecution is only working on our Rule 102.3 disclosures. Add in however many thousands of documents are outstanding to all my colleagues here, that there is a real problem with disclosure in this case, Your Honour. It's a real problem because Mr. Krasniqi and the others are sitting there in detention. They want matters to start moving. They want this case to get going. And it's this disclosure that is the sticking point, Your Honours, on all these issues. And that's why deadlines have been sought.
Thank you, Mr. Ellis. Madam Prosecutor, I invite you to respond to the 4 defense teams. And I would also like you to indicate if you have any substantial disagreement with the scope of exculpatory material, because some defense teams have presented the Rule 103 material as items that are generated, evidence that are generated by the SPO itself, but there's also been references to evidence that should be disclosed because it is generally referring to the KLA, and this could also be, by consequence, give the defense some evidence on the appreciation of the organization of the KLA, but also the question of proactive research by the SPO for potential exculpatory evidence, and I notably think of what Mr. Kihu said about some documents. So if you also have some views on the scope of your obligations here, you are welcome to present them orally. Madam Prosecutor.
First, we're aware of the requirements of Rule 103. I don't believe there's any significant disagreement regarding the scope of what would be captured by it, given our knowledge of the case and our knowledge to date of defence positions. So there's nothing to be remedied in our view, and the defence doesn't advance matters by simply reading the rule. With respect to, there were some specific examples mentioned. The Vaseli defence mentioned Chinese ammunition, and I'm actually in a position to indicate that information of that very nature is anticipated to be in an upcoming disclosure package that has recently been prepared. So these aren't items that are being missed from our review. We are aware of the scope. We're disclosing what we believe to be within the scope of the requirements. With respect to the initial submissions that were made by the Thaci defence, exculpatory disclosure is done relative to concrete confirmed charges against specific accused. So it's done relative to a confirmed indictment, and it needs to be done in the context of a protective measures regime applicable to a specific case. Within that framework, we have been working through a large collection of material. We've been disclosing it promptly on a rolling basis in accordance with the framework and the directions given. The disclosure of 751 items since the last status conference appears to be presented as some sort of an indication of a delay, but that's not the case. We've been consistent in our disclosures. We can take other periods of time and seek comparable levels of diligence and productivity. In December 2020, we disclosed over 1,300 Rule 103 items. That's almost twice as many as in this recent period. In a 6-week period in June-July 2021, we disclosed 754 items. So although we're of course allocating appropriate resources to complete the process as expeditiously as possible, our efforts have been consistent and the disclosures have been consistent. The Thaci defence submissions regarding contacts with the United States government and the degree of cooperation or material that we might have received is just entirely speculative. There's absolutely no basis to think that the SPO has access to or possession of the records of individual independent states in the manner that they're suggesting. A couple of the, or at least one of the defence teams mentioned the 70% and 30% in a manner which I believe was misleading or misunderstood the submission that we had made. It's not 30% of our entire collection that remains to be reviewed. What we're referring to there is material that has been received or cleared in the second half of last year and up to the 31st of January 2021. Similarly, the names and targeted searches was not mentioned for the first time here or in our written submissions. It's something we've mentioned in previous hearings and in previous written filings, and which we initiated in line with the finalization of our witness and evidence lists. The other point I think that was raised by the Vaseli defence was the scope of the case, but that does not impact the scope of the collection that needs to be reviewed for exculpatory content. And finally, I would make one procedural request going forward. We're disclosing thousands of items. If the Thaci defence or any of the other defence teams intend to speak about particular items, we would request that fair notice be given to enable a meaningful discussion. At the last hearing, the Thaci defence expressly did not provide such notice, despite us having made inter partes contact with them in advance. And frankly, it's deliberately sharp tactics. It's done because they don't want a meaningful discussion, and they especially don't want to be fact-checked. But we saw at the last hearing that counsel misquoted the document he purported to be citing from. So we would request, Your Honour, make the direction going forward that notice be given if there is to be detailed or specific discussion, a detailed discussion of specific items in the interests of the fairness of the proceedings. Finally, what was being said about the applicable framework, and especially the relevance of the materials in question to matters of detention, is simply not accurate. Thank you.
Thank you, Madam Prosecutor. Mr. Kihu, please.
Very briefly, Your Honor, I am shocked at what the SBO has just acknowledged, contrary to their statement that they don't need a discussion about the rule. It would appear that they do. And the word immediately is somehow dropped off their radar screen as to when they're responsible for disclosures, because of the individual that I just talked to you about, that they want to redact his name, and the other individuals who I can give to Your Honor, are all prominent people. They're not some small villager in some faraway place in Kosovo. These are prominent individuals who could never have been missed. Their names should not be redacted. Everybody knows those names. Everybody knows that they had given statements. And still we don't get that information, the first individual, 16 months down the line. So yes, I must direct my learned colleagues across the well as to what the rule says immediately. But more shocking is, yes, there is a degree of speculation on the part of the defense as to what documents they receive from the United States. We know they made document requests. We know they made many document requests. And is the prosecution at this point conceding to this court that they made no request for information that went to the structure of the KLA as far as quoting the document improperly? The document says, moreover, there is no political structure in Kosovo or effective command and control of the KLA. I can give this to you. That's what I quoted the last time. That's what I quoted this time. And is it the prosecution's position in their search for the truth that they weren't asking those questions during 10 years of this? And instead they looked at what they wanted to look at, so could they indict these gentlemen and they could sit in jail since November of 2020 for this trial that was supposed to start in April or May. But you know, that we don't hear anything about that anymore. Are they seriously not saying that they didn't ask the United States Central Intelligence Agency or any other government? Give us your information about KLA narcotics operations. And did the CIA come back and said there is no evidence to support that? Give us your information that these 4 men were involved in some type of terrorist activities. Tell us, Central Intelligence Agency. Because they obviously came to the conclusion in January of 2000 that the KLA was not involved. And it's the SBO standing before those court and say those questions were not asked by the SBO during the course of these investigations? Is that the search for the truth, Your Honor? Of course it's not. It's a search for you come to a particular conclusion, and then you want to get evidence to support that conclusion, as opposed to what actually happened. That is the logical conclusion to what counsel just said concerning this documentation, because it's shocking that they don't have it and haven't asked for this and similar other documentation from other governments. Thank you, Your Honor.
Thank you, Mr. Kihu.
Your Honour, would you hear me briefly?
Mr. Young, please.
Yes, thank you.
Briefly.
Your Honour, just on the point about 70%, I'm not sure with respect to Ms. Lawson that she answered the question that I posed and Your Honour directed towards her, unless I've misunderstood it, of course. As I understand it, the position suggested in writing is that the review is 70% complete. Again, what does that mean? Are the prosecution saying that so far we've completed 70% of the review of all the materials that's been in our custody and control? If Ms. Lawson is saying, well, there is nothing now in our custody or control that we've decided and having conducted a review is exculpatory, can Ms. Lawson confirm today, now in court, that there is nothing to disclose? Yes. She indicates that there are about 2,500 items remaining to be assigned for review, but would you want to try and help us get to an answer there, because I still don't think the question's been answered. Thank you.
Thank you, Mr. Young. Madam Prosecutor, do you want to give additional submissions on the question of the Salimi defense, please?
Yes, and indeed I realise I neglected to answer it last time. I apologise for that. With the interpretation which the Salimi defence put forward, their understanding of my submissions was not correct. We have been disclosing items identified during the review on a continuous basis, and in fact the much talked about disclosure package from the 1st of February included items from that very collection of material that has been received or cleared more recently. With respect to the Thaci defence submissions, what we're doing is a systematic item-by-item review. We're not sorting our review based on the Thaci defence's subjective assessment of who is a high-profile person. And the submissions they just made are not the logical conclusion. They're an entirely baseless jump to conclusions. I think you'll see from the materials that have already been disclosed and are in your possession that we're very interested in receiving information going to the structure of the KLA. That the Thaci defence is quoting from a document that apparently they have, but we don't have, and using that as a basis to claim disclosure violations is instructive in itself. Thank you.
Thank you, Madam Prosecutor.
Your Honor, just one point.
Sorry, Mr. Strong, I didn't see that you had requested the floor. Please, briefly.
Well, of course. Just to say that after all of that, I still don't have, and I may have missed it, but I don't have a note as to what the prosecution's best estimate for when we can have the disclosure in our possession. And I think, Your Honor, this is the third status conference that we've been pushing for it, and that's why we submit that a deadline is necessary. So we'd love to have one, and in the absence, we do submit that a deadline needs to be set.
Thank you, Mr. Strong. So let me try a last attempt with the prosecution. I think, Madam Prosecutor, you mentioned that the Rule 103 disclosure would be, and I quote, largely completed before the next status conference. Do you estimate that practically all exculpatory disclosure will be done minus a few items, or do you think that the process will last longer than the next 6 to 7 weeks?
Your Honour, I did address this in my initial submissions to the court, and on the review side, we do believe that we will have largely completed the systematic item-by-item review of the collection by the next status conference. We are disclosing material as it's identified, so there will be disclosures made up to, and I imagine including that date, but I imagine also after that date as we process what gets identified from the reviews. And separate to that is the search, as I mentioned, which right now I really cannot give an accurate estimate on, given that, you know, there are thousands of hits coming back from a single name that need to be sorted through, and there are hundreds of names that need to be searched. Thank you.
Mr. Kihu,
yes,
very briefly.
Just very briefly, one question that I would ask Your Honor to ask the prosecution. And is there some reason why it took almost 16 months for this interview that I talked about, that was turned over in February, that was taken in March of 2000, 17th of March 2000, was not turned over, 2020, my stand corrected. It was not turned over until 1 February 2022. It goes to everything Mr. Strong was talking about, et cetera. Is there some reason why counsel who took that interview did not ensure that that 103 material was turned over immediately?
Then let me ask for a final question on exculpatory material, Madam Prosecutor. Is there a specific reason why this item was not disclosed earlier?
Your Honour, this goes directly to the request I made earlier. If the defence teams wish to discuss a specific item, we need the opportunity to look into the circumstances of that item. We're disclosing thousands of them. I can't immediately give the history of the item. I can't tell you when it was transcribed. I can't tell you, it's not an answer that I can give on the spot, and that's exactly why we made the request we did. Thank you.
So I invite the parties to continue their discussions inter partes and to refer about the matter in the next status conference if needed. I see that it's approximately 1 hour and a half since we started. Let me turn to the interpreters. Do you allow me a couple of minutes for the Rule 107 material so we finish the topic of disclosure before the break? I see that the interpreters give me a yes. Okay, good. So let us now move to Rule 107 material. I note the SPO's submission that it is continuing to actively work to complete discussions with Rule 107 providers. The SPO notably indicated that significant further progress narrowing the scope of remaining items and issues has been made. The SPO indicated that it is preparing a number of further Rule 107-2 applications reflecting where final determinations have been reached. And in its written submissions, the defense observed that Rule 107 disclosure remains incomplete. I invite the SPO to make submissions on this topic, notably on the timeline for the upcoming Rule 107-2 applications. Madam Prosecutor.
We are focused on following up on the remaining Rule 107 items. An overview of those was contained in filing 678. And in terms of volume, they have narrowed further since that date on the basis of the discussions. We're currently working on 107-2 applications to submit to the court, as you mentioned. One of those is we need to resolve ongoing discussions with an individual state before we can make the application, although it's largely prepared for submission as soon as those discussions are complete. And there is a second request which is being actively prepared in recent weeks, this week, next week. There's a substantial amount of work involved in putting together those requests in order to provide the court with necessary information to facilitate decision making. So that's what we're in the process of doing for that request. Thank you.
Thank you, Madam Prosecutor. Do the defense want to...
Yes, Your Honor, if I can turn this over to Mr. Misicic for
sure.
some comments.
Mr. Misicic, please.
Good afternoon, Your Honor. Very briefly, on Rule 107 material, we just wanted to preserve our position and make you aware that to the extent there are any Rule 107 applications with respect to the Republic of Serbia, we do want to note this. It's our position that evidence that has as its source, or witnesses that have as their source to the SPO, directly or indirectly, from the Republic of Serbia or any of its organs, we would consider to be Rule 103 material because, in our view, it affects the credibility and reliability of the prosecutor's evidence. And so to the extent there's an ex parte application for Rule 107 measures or protection from disclosure, we would want to be heard on that because we think it's critical, and we do think it's critical Rule 103 material that needs to be disclosed. If we need a full discussion of why that applies with respect to the Republic of Serbia specifically, we're prepared to do that for you, but I don't think we need to take time doing that today. Thank you, Your Honor.
Thank you, Mr. Misicic. Ms. O'Reilly?
Yes, Your Honour, we would adopt those submissions indeed. it would be 103 material. And we would definitely want to be heard. Just with respect to what's outstanding on 107, we had asked in response to the filing that Ms Lawson referenced, which is F700, for quantification of what is outstanding. There hasn't been a decision on that yet, as I understand, and there's been no voluntary quantification by the SBO. So again, just to reiterate, how much are we actually talking about? I would love an answer to that question. This is all because we're trying to figure out how much time we need to devote to disclosure review, investigation and so forth, and figure out when we can be ready for trial. Thank you, Your Honour.
Thank you, Mr. O'Reilly. Mr. Young, please.
No, thank you.
Mr. Ellis, please.
We join previous submissions. Nothing to add, Your Honour.
Thank you, Mr. Ellis. Madam Prosecutor, do you want to respond to the defense submissions?
Just very briefly, as the court is already aware, Serbia is not one of the entities or countries with which there are outstanding Rule 107 issues. Thank you.
Thank you, Madam Prosecutor. I see that it's Mr. Misetic. Briefly.
Just for a clarification of the record, our position applies to any previous Rule 107 measures that may be applying to the Republic of Serbia. We would want to be heard on those as well, just so that there's no misunderstanding. Thank you.
Thank you, Mr. Misetic. It's 4:08. We're going to have a break, and we will reconvene at 4:35. The hearing is adjourned.
All rise. All rise. Please be seated.
So before we move to the next topic in our agenda, I would like to ask the parties to give an update on their inter partes discussions on legal workflow and on the electronic transmission of documents between the defense and the accused with the SEDS. I note that the Fezeli defense indicated that 3 issues have been raised by the defense regarding legal workflow. First, the documents being disclosed in early packages now being redisclosed with different titles, which significantly confuses and impedes the defense evidence review. Second, documents requested under the Rule 1023 notice being disclosed under other rules without any indication that they are part of the requested material from the Rule 1023 notice. And third, the persisting discrepancies in the document's descriptions, for example, sometimes referring to a person's name and other times referring to a pseudonym, greatly hampers the defense capacity to run comprehensive searches in the disclosed material in an efficient manner. I also note that the Krasniki defense team suffered significant delays in the electronic transmission of documents between the defense and Mr. Krasniki. I invite the other defense teams to indicate if they have recently faced the same issues. So I'll first give the floor to the registry to give an update on the discussions regarding legal workflow and the SEDS, and if the problems raised by the defense could be solved soon. And before I give you the floor, I note that the public gallery is closed. Is there a specific reason for that? No. And I see that the public gallery is now open. So I will give the floor to Mr. Nielsen on this point, legal workflow and SEDS, please.
Thank you, Your Honor. With regard to legal workflow and specifically the population of the witness entities that you have asked about in your submission, I can confirm that the registrar has inserted all the applicable protective measures, including links to the decisions themselves. As of yesterday, this has been done for all of the witnesses, so that work has been complete, and that is with regard to the witness entities as far as the registry is able to help. So that's with regard to the legal workflow. With regard to the SED issue, we received from the Krasniki defense a communication about the specific problem, and we looked into it. This system has been in place for approximately a year, and we had not seen any of the complaints of this kind before. When looking into the logs, from what we can see, the material was put on the folder, the relevant folder on 6th of March, which is what the defense indicates. And it was accessible already the day after. We have not been able to find anything else. So there was a period of a number of hours, which is normal within that system. But not the length that the defense has indicated. That's where we stand. We are happy to discuss with the defense, any defense teams, any further problems, and hopefully we'll be able to do that between us and keep that out of your attention in the future. Thank you.
Thank you, Mr. Nielsen. Does the defense want to add anything on this topic, Mr. Kihu?
Your Honor, if I may pass the floor to Mr. Ellis on this score.
Yes, just before Mr. Ellis, does any of the other defense team want to say something about this? No, I don't see any request for the floor. So Mr. Ellis, please.
Your Honor, on the specific issue of SEDS, let me say at the outset it was perhaps a little premature of me to put that on the status conference agenda. after we made that submission, we received the emails from the registry that Mr. Nielsen's just described, and we're content at the moment that that has resolved the position. So no intervention needed from Your Honour. We're grateful for the assistance from the registry, and we'll continue to engage with them directly without the need to bring it to your attention again, I hope. On the workflow forums, it's fair to say they haven't quite turned out to be the dynamic space for exchanging ideas that we had perhaps dreamed of. Nonetheless, they are continuing to meet. It is useful to have that opportunity to speak directly with the prosecution, with the registry, with the representatives of victims on the issues that are arising. Nothing specifically to report in terms of resolution, but there are various topics of discussion that are ongoing. A couple of issues on which I think we await responses from the prosecution, but we'll continue to engage going forwards on those issues. And that's as it should be. It's a dialogue, and to that extent it's ongoing. In terms of witness entities, I think it's right to say there are still some, particularly amongst the more recently disclosed witnesses, where there are no relations at all for documents. And that's something that we would invite a comment on from the prosecution, I think.
Thank you, Mr. Ellis. What you put in your submissions, I put it in the agenda of the status conferences. So, Madam Prosecutor, do you want to respond to the last question or add anything more generally on the legal workflow forum?
As the registry mentioned, relevant protective measures for witnesses have been populated, and we're grateful to them as always for their assistance with proceedings. The SPO is now also populating witness names. With respect to the matters mentioned in the Vaselli defence filing, we did indeed receive those queries at the end of last week. We're looking into the matters raised, and I confirm we will revert to the defence teams on them. In relation to the query just raised by the Krasniqi defence, I actually would invite inter partes contact on that, because just to identify who the witnesses are so that we can look into it. There are items that were disclosed during the course of January, which we're in the process of linking actually this week. So it may be that they fall within that category, and otherwise we will look into it. Thank you.
Thank you, Madam Prosecutor. Mr. Laws, do you want to mention anything about legal workflow?
Your Honour, no, thank you very much.
Thank you, Mr. Laws. Let us now move to the issue of translation of filings and evidentiary material. In its submission, the Krasniqi defense indicated that there are currently more than 1,100 filing items originally provided in English, but only 214 of them have been translated into Albanian. So I would first like to hear from the registry on the progress made with regard to the translation of these items, notably whether the parties have made any further urgent requests for translation, and whether the registry can give an estimate for the translation of the prioritized portions of the Rule 109C chart. And I would also like to hear the parties on any further difficulties regarding translations, and if there are filings that need to be prioritized. I will first give the floor to the registry. Mr. Nielsen, please.
Thank you, Your Honour. We met earlier today with the Krasniqi defense with regard to the Rule 109C chart. And looking at the complexity and the size of the material, the option that we came up with, or the proposal that we came up with, that was accepted, I believe, by the defense, was that we would provide unrevised translations, and also to provide them in batches of approximately 50 pages each, so that we will be able to provide the translation as we go along during the next month. We think that doing it in this way would be the speediest way of doing it, and that will take us, we think, for the moment, looking at the situation right now, that the last batch will be then in September. So starting as soon as possible and the last batch in September. So that's where we stand with regard to that particular translation. Besides this, beyond this request, we don't have any outstanding request for priorities for translations. Thank you.
Thank you, Mr. Nielsen. Does the defense want to add anything on the issue of translation? Mr. Ellis, please.
I need to say that we agree with that account of the meeting this morning. We're quite happy for it to be provided in unrevised version, and to be provided in batches is eminently sensible. So it was productive. Thank you.
Thank you, Mr. Ellis. Mr. Laws, do you have any remarks on the issue of translations?
No, thank you, Your Honor.
Thank you, Mr. Laws. Madam Prosecutor, do you want to add anything? Mr. Prosecutor.
Nothing from the SPO on this, Your Honor.
Thank you, Mr. Prosecutor. Now I turn back to the SPO to ask about the status of its ongoing investigations. In its written submissions, the SPO indicated that its investigation in this case is largely completed, and that no currently contemplated steps implicate amendments to the indictment or the SPO's overall case theory, nor would they require resolution before the case is transferred to the trial panel. However, the SPO indicated that new investigative leads may be discovered, and such leads may uncover evidence necessary for the determination of the truth. Witness may, for example, become unavailable and or uncooperative, justifying a reasonable opportunity to identify substitute evidence. I wish to remind the SPO that general investigations shall not continue throughout the trial. Only investigations that are the result of new events or information shall be performed. As I said during the last status conference, Rule 102.4 confirms that only under exceptional circumstances can additional evidence be disclosed and subsequently used at trial. In its written submission, the SPO considers that its investigation is largely completed and no deadline is therefore necessary. However, the defense submits that at this point, I should fix 6 May 2022 as the date by which the SPO should complete its investigation. So I would like the parties to indicate whether a formal deadline is necessary, and if so, what would be the exception for the investigations that could be performed after this date. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. You have accurately summarized our position and exactly why we would say that no deadline is necessary. Incidentally, largely complete is not our catchword, to use Mr. Kehoe's phrasing. This was actually the way that Your Honor described what was necessary for the level of completion of our investigation on page 928 of the transcript at the last status conference. So unless Your Honor has any particular questions as to our investigation, we've heard Your Honor's directions, we're aware of the statutory restrictions that apply at this time, and we have no further submissions.
Thank you, Mr. Prosecutor. Mr. Kehoe, please.
Yes, Your Honor, I will speak just briefly, and then if I could hand the floor to Mr. Thaci for additional comments.
Then very briefly, because...
Very briefly, Judge, very briefly. I
am quite flexible, but try to divide the topics between you, because if we double up, it becomes very, very long.
If he talks too long, I'll just pull him down, Judge.
He's usually very short and very concise, Mr. Kehoe.
Judge, I just want to direct Your Honor's attention back to what you had said on the 4th of February in our last conference. And Your Honor said, and this is on page 928, the defense cannot be expected to prepare a defense on a case that is constantly evolving. And we were talking about this issue, something that's constantly evolving. If, in fact, and when I first read the SPO's comment about largely complete, I don't know what that means other than it's complete. If it's complete, end it now. There's no reason for this to go on any further. But the point of the matter is, and the reason why this has to be closed now, is we constantly have a constantly evolving prosecution case that's been going on for 10 years. And heaven knows our clients have been in custody since November of 2020. That's the problem without listing a deadline. If it's largely complete, give them a deadline, and after that, it's over. Mr. Misicic.
Mr. Misicic, please.
Thank you, Your Honor. Just briefly, if there's going to be a debate about what largely complete means, our view is Rule 98 requires you at some point to transmit the file to the trial panel. Rule 108(1) B and C requires you to transmit the evidentiary material to the trial panel. Our question is simply, when will the prosecution be in a position to state that the material it wants you to submit to the trial panel is now complete and ready for transmission? So what is largely complete or what isn't, that's our definition of what complete means. Thank you.
Thank you, Mr. Misetic. Ms. O'Reilly, please.
In fact, can I?
Sorry, Mr. Emerson.
I do apologise. Can I address Your Honour on this issue? In particular, because it's really a fulcrum question, and you've said as much in the last status conference. Our position is relatively simple. No one is suggesting that the 6th of May would be a cut-off date that prevents the prosecution applying to the court for leave to adduce additional evidence, and you specifically asked for submissions on what should be the test for regarding evidence as fresh. We make the point that there is already an unprecedented mountain of evidence, much larger than any international criminal case ever, that has been put before you and is being disclosed to us. There has to come a point where, as you've rightly acknowledged, we can say, okay, that's the finite case we have to meet. And that, for us to be having a discussion in March 2022, about when the prosecution should finish serving its case is in itself pretty staggering, given the length of time that the proceedings have been ongoing. And I venture to suggest the real problem at the heart of this case is, number one, Mr. Black's decision to make the
Mr. Smith.
Sorry?
Mr. Smith.
I've done it again. Sorry, Mr. Smith's decision to announce that he had filed a set of papers before Your Honour and was intending to prosecute Mr. Thaci and Mr. Vasili at a time when clearly the prosecution was nowhere near ready to prosecute. And what we've seen is that since the confirmation and the detention of the accused, that the prosecution is doing the work that, to be honest, a responsible prosecutor and every other prosecutor I have experienced in the international arena would have done before issuing an indictment, so that the trial with people in custody can then proceed efficiently. You know, we should have had the prosecution's case in full within a matter of weeks of the defendant's arrest, and thereafter not adding any further material without permission of the court. In terms of the test, I think that's the key question. We would submit that the right test is what's normally referred to internationally as the fresh evidence test. In other words, it has to be evidence to which the prosecution did not have access to and could not with reasonable diligence have had access to prior to the 6th of May. Therefore, it's fresh in the sense that it's material that has come into the prosecution's possession in a wholly unforeseen manner. But they ought most certainly, by the 6th of May, to have disclosed everything that they have, subject to subsequent developments. Now, why would the prosecution resist a guillotine or a date fixed for the introduction of that fresh evidence test? The answer can only be that they anticipate that they're not going to meet the 6th of May deadline, or is it the 6th of May? Sorry, let me just check my note. That they're going to, the 6th of May deadline, because if they are going to meet it, as they imply, they should have no objection to the imposition of a fresh evidence test after the 6th of May. So it's actually quite a modest restriction on the prosecution's ability to prosecute this already indiscriminate case, indiscriminately prepared case. It just means that they've got to stop just shoveling large amounts of evidence into their case in the hope that something's going to stick. So we all know what the nature of the case is at the moment. It's a lot of evidence that amounts to very little. and all of it has to be investigated nonetheless. So, frankly, anything other than a 6th of May cut-off deadline is going to leave us talking to you about a trial starting well into 2022. If they can carry on through the summer, adducing evidence that they either had or had access to, or could have with reasonable diligence have discovered, way into the autumn, I'm afraid we won't be able to file a pre-trial brief. We won't be able. We have to know the case. We have to meet. So I'm repeating myself, which is always a good sign that I've reached the point where I should stop. But those are our submissions fundamentally.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, I can be brief. The prosecution say, Your Honour, that there's no need for a deadline. If there was ever a case which needed a deadline, it's this case. And for reasons I'm sure Your Honour understands. If the prosecution now say they are confident that the investigation is largely completed, then I ask rhetorically, why should they be fearful of a deadline? We do support Mr. Emerson's submission that there should be a deadline, a cut-off date of the 6th of May for good case management reasons. So we ask you to make that deadline and to take charge of this matter.
Thank you, Mr. Young. Mr. Ellis, please.
Yes, Your Honour, we join those previous submissions. We see no reason why there can't be a deadline imposed. And in the light of all the issues we're having with the disclosures as well, dragging on longer, here's something where we can draw a line and hopefully move things along.
Thank you, Mr. Ellis. Mr. Prosecutor, on the deadline proposed by the defense, the fact that it would be the 6th of May, and also on the proposal to apply the fresh evidence test made by Mr. Emerson. And if I understood you correctly, the deadline is already over for you because you finalized your investigations, except if you were to look for evidence due to unforeseen circumstances. So I think you're not very far from Mr. Emerson's proposal, but maybe I misunderstood your submissions.
We'll first address the 6th of May deadline. Your Honor is correct that the reason why a 6th of May deadline is unnecessary is because of what we have already committed to. The deadline would be to impose something to ensure that the investigation was largely complete. And even discussion of things like fresh evidence tests or a tacit acknowledgement that these kinds of issues can arise at any point during the trial. In terms of what the actual test would be, there are statutory provisions applicable here, and we would suggest that that be addressed if and when it happens. There are investigative steps listed in paragraph 12 of our written submissions. These aren't necessarily things that are currently outstanding investigative steps. There are kinds of things that could well happen with the ongoing progress of the trial. One of them, for instance, is defense witnesses and information being disclosed, which would necessitate further investigations, and I don't think anyone here would say that that's happened yet or that it needs to happen yet. We have some other aspects of our investigation that are concerning things like interviewing witnesses who have already been interviewed on the SPO witness list, or outstanding requests for forensic information relating to murder victims in the indictment. And these kinds of things, when they are ready, we will be in a position to make a filing. But as we've said all along, this does not affect the scope of the indictment, and it doesn't affect the SPO's overall case theory. These are details within matters that are already within the scope of the defense's investigations. The case that needs to be met by the defense is the one in the confirmed indictment as informed in the Rule 86 3B outline and the pretrial brief, and the evidence that the SPO is using is that disclosed under Rule 102.1b. And we are aware, and Ms. Lawson already said it, that if we want to add Rule 102.1b material at this point, that additional or appropriate scrutiny from the pretrial judge would be applied. Thank you.
Thank you, Mr. Prosecutor. Mr. Kihu first.
Yes, Your Honor. At the outset, my learned friend has said a question is about the SPO has committed themselves to something. What have they committed themselves to? They haven't committed themselves to anything. They haven't committed to a timeline. They're resisting the 6th of May timeline, and they didn't answer your question about the fresh evidence test. Next, the bottom line at this point, judges, are they ready to tell this chamber to transfer this case, this file, to the trial panel? If they're not, they're still investigating this, and if the only thing that we're supposed to address is the indictment that's before us, what's the need for this additional investigation? Clearly, they are trying to generate yet more information, more of the piles of information we have, and they don't appear to be anywhere near ready to tell Your Honor to transfer this file to the trial panel. Now, as far as their commitment to, they haven't committed to anything. The bottom line is there must be an end. There must be an end to this investigation. And as Mr. Emerson said, if in fact they pass the fresh evidence test, we can address that at that point. But now this has to be over. Again, to use Your Honor's words, they have a constantly evolving case. And if there weren't the need, if it was not constantly evolving, there would be no need for this additional investigation that they're purportedly doing. Again, we submit to Your Honor to set a deadline. At this point, after all of this time, the 6th of May is eminently reasonable.
Thank you, Mr. Kihu. Mr. Emerson, please.
Just 2 short points in rejoinder. First of all, if this were a prosecutor who had met their previous deadlines, coming before you and saying you ought to trust us because we say we've done most of it already and that we won't go very much beyond that, I'm afraid this is a prosecution that has repeatedly misinformed the court about time estimates from the very beginning, suggesting that this trial was going to start in June of last year onwards, has repeatedly broken indications of when the case was going to be prepared, with a cumulative result of that there's a monstrous mountain of evidence which has not been properly organised, sifted or focused. And we end up in a situation where now the prosecutor stands up and says, well, you don't need to give us the direction because we're the prosecution. But I'm afraid the past practice of the prosecution in this case is in itself a reason why you ought to very seriously consider the imposition. It's not a deadline anyway. It's the imposition of a fresh evidence test. Of course, we accept, and the test acknowledges that if it's material that's arisen, what we used to call ex improviso, in other words, it's something that's come from evidence adduced by the defense or from something that emerges from a witness that was unanticipated, or anything that couldn't have been realistically obtained before the 6th of May and served, then clearly that's material which will likely satisfy the test. But it should require at least an application to Your Honour or to the trial chamber if we get to that stage, when the prosecution wants to adduce further investigative evidence, and they'll clearly satisfy the test in the sort of examples that they put in their note for today's hearing, such as evidence emerging at trial. But what is, in the end of the day, what is the objection to the imposition of a rule that says after the 6th of May, you're going to need judicial permission on that test? And frankly, nothing that's been said on the prosecution side could begin to address that issue, especially given the history and conduct of these proceedings to date. I won't go into that any further because Your Honour is very familiar with it.
Thank you, Mr. Emerson. Mr. Prosecutor, on the question of the transmission of the case file raised by Mr. Kihu, and also I think there is a general agreement that you all, and especially on the prosecution side, consider that you need judicial permission to disclose any further Rule 102(1)(b) material, which means in fact that the deadline already starts applying today, because basically there should be scrutiny by either myself as trial judge or by the trial panel in the future to accept that this evidence is admitted. So, and there will certainly be a test that to be applied at that point. Am I right, Mr. Prosecutor?
Fully correct, Your Honor. That's exactly our position. The only other thing that we wanted to say in response, Mr. Kihu misquoted Your Honor in the last status conference, and it's an important point. On page 928 of the transcript, Your Honor says that Rule 1024 confirms that objective. Your Honor said something similar today. Only under exceptional circumstances can additional evidence be disclosed and subsequently used at trial. The defense cannot be expected to prepare a defense on a case that is constantly evolving. The court did not say that the SPO case is constantly evolving. Your Honor was talking about the disclosure obligations and the purpose of provisions like Rule 1024 in the abstract. The SPO resists the notion that its case is evolving or has been constantly evolving, and at that level, we have no problem with our investigation as it stands being transmitted to the trial panel with the guidance that Your Honor's just given.
Thank you, Mr. Prosecutor. I don't see any request. Mr. Kihu,
Just
very
briefly,
briefly,
Judge,
please.
that if that is true, then just let it be done. Just shut this thing down, transfer the file, and move to the fresh evidence test that they'll have to advance in front of the trial chamber. That's the answer. I mean, we're talking about words going back and forth, constantly evolving. They're still investigating. Of course, it's constantly evolving. What are they doing if they're not investigating? They're trying to protract this case out and find other things. Shut this down, Judge, and make it transferred to the trial panel and have their investigation be done. And if they want to change anything, the fresh evidence test is there.
Thank you, Mr. Kihu. For the next point on the agenda, I would like to turn to the defense first. So regarding defense investigations, I've heard that several defense teams have mentioned that as long as the disclosure is not completed, it's very difficult to propose any timeline, whether it's for defense pretrial brief or for the investigations in general. Nevertheless, I would be interested to hear the defense regarding the status of their investigations, and any information about timelines would be appreciated, even if I fully understand that it's difficult to commit to a specific deadline today. Mr. Kihu.
Yes, Your Honor. Let me be clear. We want to file our pretrial brief as soon as we can. We want to get this case to trial as soon as we can. But to say that our investigation, our investigation is ongoing, and we are investigating, notwithstanding all of the restrictions that we have. And we're talking about a number of factors. How about the extensive redactions, even to the indictment, to witnesses' statements, the anonymous witnesses. We have 103 out of the 326 witnesses that are, in fact, anonymous. We have continued 102.3 disclosures, and heaven knows what's most important at this point is the 103 disclosures that have not been given to the defense. It is difficult, if not impossible, for the Thaci defense to give you a timeline on that, Judge, because we still have all of these outstanding issues. That being said, Judge, we are, to the best of our ability, investigating this case in conjunction with our client on a steady basis.
Thank you, Mr. Kihu. Mr. Emerson, please.
It's in fact going to be Mr. Strong addressing this issue because he's the principal advisor on the investigation.
Mr. Strong, please.
Yes, thank you, Your Honor. We've completed the initial review of the SPO's pretrial brief, and I can address some issues we had with that in another section of the status conference. But to say that we have now completed a first investigation trip to Kosovo. There are a couple impediments that I've outlined in our submissions, but I wanted to spend a few minutes on here that we're finding in this investigation. The first is trying to meet the scope of the prosecution's case. Your Honor, we have a professional obligation to prepare a defense that meets the case that's brought against us. And here, as Mr. Emerson noted, that the volume of information, certainly in my experience, is unprecedented. I didn't want to just rely on my experience, and so we did survey 53 international criminal law cases to try to get some guidance. I think we were clear that this is not exhaustive, but to say that this case and the volume of information is an outlier by any metric, whether it's trial hours, witnesses, or the number of exhibits that are proposed. It's 10 times the trial hours of the Shayanovich case, 10 times the exhibits of the Shayanovich, Georgievich, and Stanisic cases. And those are the sort of flagship ICTY cases involving the Serb ethnic cleansing campaign in Kosovo. So that's why we chose those as benchmarks. But the point is, by any metric, this case is too big. And for the investigation purpose, if it's to be cut down, we want to do it sooner rather than later, so that the limited resources that the court has and that the defense has aren't spent tracking down issues that will ultimately be dropped. If the SPO is resolute in saying that this case shall not be cut at all, then we would like to hear how they propose to deal with some of the immutables here. I mean, there is just a math problem with 1,863 hours. If you divide that by 4 hours per day dedicated only to leading evidence, it comes out to something like 465 days. Now, how many days can this court sit? There can be conflicts with scheduling. That doesn't calculate the cross-examination. This is a math problem, and we'd like to hear how the SBO intends to solve it, because we have a client in custody that is paying attention and sees the potential for a 10-year trial looming on the horizon. And I think nobody in this courtroom wants to see that happen. And so the sooner we can address that, the better. The second impediment we faced, Your Honor, we dealt with earlier, but it's the late disclosure of Rule 103 material. I mean, we had the experience just in the last 6 weeks where the defense has spent resources and time, sometimes months, trying to pin down an issue that, a 103 witness that gave an interview in 2019 can deal with in a matter of minutes. And given the size of this case, that's not a workable path forward to carry out an investigation. And so that's yet another reason why we really need to get that information in our possession as soon as possible. The final point we make on timing, Your Honor, is that we've heard the prosecution say on a number of occasions that the defense case doesn't have to be complete to start trial. And we are open to pursuing any avenue to expedite this trial. But if that is to be even considered, we do need to know the order of the first batch of witnesses that the prosecution intends to call, so that we can allocate our time and energy accordingly. We've asked for the first 30 witnesses, which is just a number derived from the first 10% of their case, and then the first 107 witnesses, which is the 30%. But we would like the specific order of the first 30 witnesses so we can focus on them, and then the general order, the general number for the first 30%. That's all with an eye towards trying to start this case sooner, and that's where we're coming from, Your Honor. Thank you.
Thank you, Mr. Strong. Mr. Young, please.
Yes, very briefly. Your Honor, the reality is that defence investigations are ongoing, but as my learned colleagues have addressed you, we are being significantly hampered by issues that I think you understand, Your Honour. As my colleagues said, the scope of the redactions to the indictment, the redactions to the pre-trial brief, redactions to the underlying material, the enormous number of anonymous witnesses, the delays on SBO disclosure, particularly on 102.3. Your Honour, Your Honour's heard earlier in this hearing that we have identified tens of thousands of documents that we have deemed to be material to the preparation of the defence. We don't have them. We're not clear when we're going to get them. So unless there's going to be litigation of the materiality, and prima facie they are they are material to the preparation of our defence, and we don't have them. It's difficult to talk about defence on investigations. So there are a whole host of reasons why a lot more time is required. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Yes, Your Honour, like other defence teams, we are progressing our investigation. We're moving as fast as we can with the constraints that we have. We too have had a recent investigative mission to Kosovo. We've spoken to potential witnesses both there and indeed elsewhere. And we have further investigations planned in the near future. But none of that undermines the position that I outlined at in earlier agenda items, which is that what needs to come first is a completion of prosecution disclosure, and then we'll be in a position to give Your Honour a much more meaningful input in terms of deadlines. And we do join the submissions advanced by other defence teams, in particular the submission advanced by Mr. Strong, seeking early disclosure of the identities of the first prosecution witnesses, because that seems to me to be an entirely sensible step that would help us to target the investigation at those that will come first.
Thank you, Mr. Ellis. Let us move to the last topic.
Your Honour, could we be
sorry.
heard on that before we move to the next agenda item?
Yes, sorry, you want to...
Yes, just a few short responses and then one longer one about the scope of the SPO's case, because it was directly implicated by what the Vasselli defense argued under this agenda item. It's obviously important that all the parties exercise diligence in getting this case ready for trial. It's the defense's prerogative to investigate how much it wishes, but the transfer of the case record to the trial panel can't be conditioned on the basis of investigations that the defense could do and chose not to do. There are also some things that have been inconsistent in the defense submissions in the past on this point. I direct Your Honour to pages 971 to 972 of the transcript, specifically as to the Thaci defense's previous submissions. And there are some things that were said just now that are actually disguised reconsideration requests of Your Honour's past rulings. The redactions in the indictment, the pretrial brief, and to witness statements, the non-standard redactions have been judicially authorized, and they are applied on these documents. So the defense saying that they need this information in order to investigate is kind of creating a loop where they aren't ever going to investigate until these procedural conditions are met, and they won't be met until 30 days before trial, 30 days before testimony. Your Honor has set the schedule for individual witnesses. As to a witness order, the order of SPO witnesses is heavily dependent on when the trial commences, the trial panel's sitting schedule, and the availability of witnesses at the scheduled time. We would ask that that matter be deferred to the trial panel for it to determine how and when to convey the order of witnesses. But as I said, the main point I wanted to address here is on the scope of the case. Your Honor, the indictment in this case was confirmed. The SPO is entitled to a fair opportunity to present that case. This opportunity is connected to proposed exhibits, to examination hours, and to disclosure of evidence. The pattern of criminal conduct exposed by the full array of charged crime sites is particularly important in this case, noting, for instance, that the ICTY prosecution was found to have failed to establish a widespread or systematic attack against the civilian population in the Limay et al. And Haradnay et al. Cases. And specifically, that's paragraph 228 of the Limay et al. Trial judgment and paragraph 122 of the Haradnay et al. Trial judgment, the first one, 3 April 2008. The numbers, the statistics that the Vasselli defense presented to Your Honors both now and in their written submissions on the unprecedented nature of the SPO's case, they do not allow for a meaningful comparison. The presentation of the statistics in this manner, it's not only not meaningful, it's actually misleading. And I can give you two reasons why. First, as noted by the Vasselli defense itself in its written submissions, these numbers in this annex that they have filed are for admitted exhibits, and they're not for items on the original list. The current SPO list of exhibits reflects what could be admitted at trial. But it can be anticipated that, like in all proceedings, The actual number may end up being significantly less. As an example, the Karadzic case referenced in the table, the over 6,600 items that were admitted into evidence in that case. In contrast, the ICTY prosecution's list of evidence ended up exceeding over 23,000 items as that trial went along. The second point to mention is that the SPO sets out its exhibits in a more long-form style than those of the ICTY or other international tribunals. Just as another example, one interview the SPO has put on its list of exhibits is an interview with witness W00344, but it's not one item in our list. It's actually a 5-part interview with 5 PDFs, and then it has 5 Albanian translations and 5 Serbian translations attached to it. So actually items 16 to 30 on our list of exhibits are just the interview with this one witness. The way in which an exhibit is counted has a dramatic effect on the numbers the Vesely defense relies upon. This case it's undoubtedly big, but allocations that the case is unprecedented reflect more of selective number crunching than the actual scope of the case. And notwithstanding all that, the SPO is mindful that examination hours can't simply be unlimited, and we are not resolute in this regard, and that we wanted to address under the streamlining agenda item. Thank you.
Thank you, Mr. Prosecutor. Mr. Kihu, briefly, please.
Just briefly, Your Honor, then I'll just say one thing briefly, then Mr. Misetich. I think that counsel is completely missing the point. The point is that the defense has been significantly handcuffed in finding out much of this information because of what the SPO did. They've put on their list 360-plus witnesses for 1,863 hours. That's years in the prosecution case. Is there another case that has come up that is anywhere remotely close to the hours advanced by the prosecution? Of course not. So the position that is taken by the SPO that this is just another run-of-the-mill case is absurd. Of course this is an immense case in things. If they want to cut this case down, give us a realistic list of witnesses. Because we've talked to some of the witnesses on this list. They don't even know they're witnesses on this list. Put aside the fact that they never got consent for Rule 80 measures. They don't even know that they're witnesses. Get rid of those witnesses. The prosecution's not going to call them. They put this witness list together to try to lock us out from them. We are not saying that all the T's and the I's have to be dotted in the defense investigation by the time this case starts. We have never advanced that position. But we are working diligently with significantly redacted information with a third of their witnesses that we don't even know who they are. And that has always been our position. If we want this to move more quickly, take all these redactions out. How about give us a copy of the indictment? Just a defense counsel. That's
Mr.
not
Q, all these redactions have been judicially authorized,
Understood,
and
Judge.
all my decisions can be appealed.
Understood, Judge. But we are talking about some kind of argument coming from the prosecution that we have not been hampered by these restrictions. Let me just turn it briefly to Mr. Misetich.
Mr. Misetich, please.
Thank you, Your Honor. Just briefly to address the point that we were somehow inconsistent in our position. I think we're talking about an argument in the context of the protocol, and there's been a misrepresentation of what our argument is. Our argument isn't that we started our investigation in November and December of 2020. It's that the prosecution disclosed their witnesses to us in November and December of 2020, and yet allowed us or felt comfortable enough with us conducting an investigation, including contacting their witnesses, until they filed the application in December of 2021. That was the only point we were making. We did not say we started our investigation back then. And I would just say that this is really a matter of evidence. They're in contact with the witnesses. If they come into information that we were interviewing witnesses prior to the time that we said we were, it's a simple matter of evidence, and they can come forward with the witnesses' evidence to confirm that we somehow misrepresented something to the court. Thank you.
Thank you, Mr. Misetich. Let me now move to the last topic on our agenda, which is related to efficiency and expeditiousness of the proceedings. And I know that we've actually already started discussing on this point because, Mr. Strong, you already presented orally what you indicated in your written submissions, which are already concrete proposals to streamline the case. In the scheduling order, I asked the parties, and this followed what Mr. Emerson said during the last status conference, whether they would be in a position to conduct inter partes discussions and or file written proposals to streamline trial proceedings that will be included in the handover document provided for in Rule 98E of the rules by the 12th Status Conference. I gave a couple of examples of the measures that could be discussed, notably time limits for the presentation of the parties' cases and or for the questioning of witnesses, limitations on the number of witnesses, or the use of written evidence and bar table motions. I will not recall what was in the Vesely submissions because, Mr. Strong, you recalled them already. But I do not invite the parties to discuss about the substance of these proposals now, but I would like the parties to indicate first if they agree to conduct inter partes discussions on this topic during the following weeks, and or if they can provide submissions on this topic before the next status conference. Mr. Prosecutor, please.
Thank you, Your Honor. The SPO remains open to discussing any matter which will potentially streamline the proceedings, and we're happy to do that on an inter partes basis. I'll give a little bit more information even now as to what kind of proposals that we have in mind, because in our submission, there's really two principal paths to streamlining the proceedings. There can be a reduction of the number of issues in dispute, and the SPO can reduce the hours, its hours estimates. As to reducing the number of issues in dispute, no meaningful progress has been made thus far. The SPO proposed 387 agreed facts in March 2021. It received little substantive engagement until only February 2022, and that engagement was primarily by way of superficial queries for additional information on certain proposed facts. What date was this? Who were these people? Rather than any affirmative proposal from the defense as to what the dates could be, etc.
Mr. Prosecutor, when the defense hasn't received all disclosure, it is also difficult for the defense to agree on facts. So once you'll be done with your disclosure, I will hear you with great interest. But for now, I think it's quite difficult for the defense to conclude these discussions.
Absolutely. And to add to that, Your Honor, I would also say the defense don't actually have to agree to anything in this case, even once this information is provided. They don't need to agree about the founding of the KLA before the charge time frame, or any detail about the LDK, the date of its establishment, or Kadri Vesely's birthday. Incidentally, these are all unagreed, proposed agreed facts. But the defense's current position, where it currently stands, does put a limit on how much streamlining is possible. It would be of great assistance if the defense could, in a consolidated way, before the next status conference, propose a consolidated list of what relevant points of fact in law they are comfortable with proposing, and whether they have any objections to the admissibility of evidence that's currently on the list of exhibits. And that last indication would inform a bar table motion that the SPO would intend to file before the trial panel. As to reducing the SPO's hours estimates, the SPO has undertaken an internal initiative to significantly reduce the hours estimates in this case. In particular, we will be reducing questioning time for certain witnesses, and we'll be eliciting more evidence through Rules 153 to 155 of the rules. As Your Honor can appreciate, this is an exercise of careful balancing. The SPO is entitled to a reasonable opportunity to prove the case is charged, and this opportunity is informed by provisions like Rule 140, Sub-Rule 4 of the rules, which limits the use of statements of witnesses whom the defense could not examine in the trial judgment. And there are also non-evidential factors as well, such as that there are some victims where it's very important to them to actually tell their story directly to the judges of the trial panel. And this is also something we're taking into consideration. But the SPO is committing to shorten its estimated case. Even though such matters will be discussed before the trial panel, pursuant to Rule 118.1 of the rules, the SPO is endeavoring to propose what reductions it can while the case is still before Your Honor. We will be able to update the pretrial judge at the 12th status conference as to how many hours have been reduced to that point and what the prospects are for further reductions. Thank you.
Thank you, Mr. Prosecutor. Mr. Kihu, please. And again, no discussion on substance today. It's really the process for a longer discussion on this topic at the next status conference.
Yes, Your Honor. We have three rudimentary suggestions. I mean, obviously, as Your Honor knows, 3 days ago, we received yet another amended list, exhibit list, that we now have 16,298 items on that list, and the pages on is 1,290, amended again as of 3 days ago. So that is the exhibit list that is now before Your Honor. We have 326 witnesses, and of course we have my favorite document, the 1,863 hours. Clearly, the prosecution can limit this three ways. Let's take the number of witnesses that they're not going to call, because they're not going to call 326. All of those witnesses that we've been talking to that don't even know they're on a witness list, the prosecution's not calling them. All of the exhibits attendant to that testimony, they can knock out. That would knock out the witnesses, that would knock out the hours, and it would knock out the exhibits. That's a first run through the SPO's case. And let's get down to a case that we're actually going to litigate in this courthouse. And we can begin to have a discussion. The ball, is, use an expression, is in their court, and they have very, very concrete things they can do to shorten this matter immediately.
Thank you, Mr. Kihu. Mr. Emerson, please.
I'll stay focused on the procedural aspect, if I may. We're more than happy to engage with the prosecution as to the process of reduction in the scope of its case. But I wouldn't want to waste too much time on inter-parties discussions that are unlikely to prove fruitful. So I think the sensible course is we will ascertain what their position is, but we will file written submissions for the next status conference. Our position, let me make it clear, is that the only way of achieving some discipline in the presentation of the prosecution case is to do what all other international criminal tribunals have done, and to say, this is the length of time that the prosecution has to present its case, and it's for the prosecution to decide which witnesses it wants to focus on. One of the great disciplines of any time limit is that for trial is that it forces the party to whom it applies to focus their minds. And whereas until now it's perfectly obvious that the approach of the prosecution has been to throw everything in the mix, including the kitchen sink, that is not a responsible or even viable way of prosecuting a case. So it's good to hear that there is some willingness to reduce the estimate of hours, but fundamentally what's going to be needed is a fixed time limit, and leaving the prosecution then to make a decision as to the priorities. Now, if one looks at, I think the simplest way of going about it is to say, what does the pre-trial judge or the trial chamber consider to be a reasonable length of time for this case to go on, bearing in mind that there are 4 defendants, and therefore any estimate attaching to the prosecution's case needs to be doubled, because there are 4 accused to answer the case. So at least doubled, but I'm saying that as a minimum. So if, for example, the judicial officer making that decision, whether it's yourself or the trial chamber, comes to the conclusion that, for an allegation like this, 2 years is how long a trial should maximum go for, 2 further years in custody, or 18 months, or whatever figure is chosen, half of that time belongs to the defense, and the other half is the limit of how long the prosecution has to present its case. And it doesn't take me to convince Your Honour, because I think we're probably all familiar with it from years of experience, is that whilst the pips may squeak when you put the pressure on in terms of time, in the end, the case will be much cleaner, much better presented, and much leaner if the discipline is imposed. I mean, I know speaking as an advocate myself, you know, when there's a time limit on how long you have to cross-examine a witness, you don't go on for hours and hours rambling around the houses and boring everybody until you get to your main point. You get to your main point straight away. And, you know, that's the same approach that needs to, you know, the prosecution, I think we all know that this has been unprofessionally prosecuted, and that the material that's been put in includes vast swathes of irrelevant material in support of a case that doesn't have any real allegations against in it. But be that as it may, they're bound to squeal if a time limit is imposed on them. But in the end, they'll be grateful for it, because it will help to clarify the issues on both sides by having a clearly presented case. At the moment, honestly, from a defence point of view, reading the pre-trial brief and the evidence and the other material that's coming through, it's befuddling why this case is ever brought to trial.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, may I just say that we will also engage with the prosecution. We're always willing to do so. As far as the other points made, I would simply endorse what Mr. Kehoe and Mr. Emerson said, and I don't think repetition helps.
Thank you, Mr. Young. Mr. Ellis, please.
Yes, Your Honour, it's very much the same position from us. The record will show that we're always open to inter partes discussions, and this is no exception.
Thank you, Mr. Ellis. Mr. Laws, please.
Well, thank you. This is a topic in which we do have an interest, and I just wanted to say for the record that we would also be very happy to take part in inter partes discussions with a view to streamlining the case. Thank you.
Thank you very much, Mr. Laws. I thank all the parties and participants for their willingness to start discussions, and I agree with Mr. Emerson. This shouldn't last for 6 months. I think that these inter-partes discussions needs to be limited in time, and so I will invite all the parties to finalize their discussion before the next status conference. And talking about the next status conference,
before you move on, could you specify that inter partes discussions must be concluded sufficiently far in advance of the next status conference for the parties to have time to file their written submissions? Because I think we're almost certainly going to get into a submission situation.
Point taken. I will issue an oral order on this at the end of the status conference. So for the date of the next status conference, I initially intended to schedule the next status conference on 16 May, but the date is unfortunately not possible anymore. And so I intend to schedule the next status conference on Friday, 20 May 2022 at 14:30 Hague time. So I invite the parties, as usual, to confirm their availability. Madam Prosecutor.
Yes, Your Honour, we will be available at the court's convenience. Thank you.
Thank you, Madam Prosecutor. Mr. Kehoe, please.
Yes, Your Honour, we will be available. Thank you.
Thank you, Mr. Kehoe. Mr. Emerson, please.
Yes, that's absolutely fine.
Thank you, Mr. Emerson. Mr. Young, please.
We will be there. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Yes, Your Honour, we'll be here.
Thank you, Mr. Ellis. Mr. Laws, please.
Well, yes, we'll be there. Thank you.
Thank you, Mr. Laws. You will receive a scaling order that will include the agenda before the status conference in due course. At this point, I would like to ask the parties and participants whether they have any other issue they would like to raise. Mr. Prosecutor.
Thank you, Your Honor. The only other issue that we were intending to address was the Thaci defense's proposed supplemental submission on a witness contact protocol, which is filing F00741. Doing so now would obviate the need for a written response, but we're in Your Honor's hands if you would like us to respond now. It was referenced by the Thaci defense in today's hearing.
It depends how, do you want to take the floor for a couple of minutes, or do you need more than that?
I'll say 5 minutes at the utmost.
It is 5:41. We are close to the end of the status conference. Mr. Misetic.
Sorry, I just wanted to say that you should also factor in that I'm almost certain we will have something to say.
You read my mind. That's what I was factoring in. I would rather you make written submissions, Mr. Prosecutor.
Happy to, Your Honor. That's all we have.
Thank you, Mr. Prosecutor. Mr. Kihu.
Just one issue, Your Honor, on the anonymous witnesses that we have. We have any number of anonymous witnesses with protective measures, and many of these...
Who will not be anonymous until the end of the proceedings, because...
Well, my point, I just wanted to...
And who have been all authorized
Yes,
by
Your Honor,
myself,
no question.
Mr. Kihu.
But with regard to those witnesses, my understanding from media issues in Kosovo, many of those people have gone public with their position. And we asked the Chamber to have the SPO review those witnesses, and if the protective measures are no longer necessary, the Rule 80 protective measures, that they be removed. And we move accordingly with those witnesses just as any other normal witness, as opposed to one with protective measures.
Thank you, Mr. Kihu. Madam Prosecutor, do you want to respond to Mr. Kihu?
Not at length, Your Honour. We obviously keep the individual security situation and the individual circumstances of witnesses under constant review. Thank you.
Thank you, Madam Prosecutor. Mr. Emerson, please.
Nothing, Your Honour.
Thank you, Mr. Emerson. Mr. Young, please.
No, thank you.
Excuse me, Mr. Young. Mr. Ellis, please.
Nothing further, thank you, Your Honour.
Thank you, Mr. Ellis. Mr. Laws, please.
Nothing further, thank you, Your Honour.
Thank you, Mr. Laws. Before we conclude today's hearing, I will issue 3 oral orders. My first oral order concerns the reclassification of filing F744. On 22 March, in a written filing, the SPO requested the reclassification of filing F744 as confidential. The SPO asserts that information which was disclosed to the defense on a confidential basis should remain confidential despite the potentially public availability of any such information. The Vesely defense responds that filing F744 need not be reclassified as confidential as the SPO interviewee is not a protected witness, and the SPO's relationship with the relevant authorities is in the public domain. The SPO replies that the Vesely defense is not justified in sidestepping the applicable legal framework and of its own initiative reclassifying the confidential information contained in F744. In light of the submissions of the parties, I find that while some general information regarding the matters concerned can be found in the public domain, the details of these matters and/or confirmation thereof remain confidential. Therefore, I order the registry to reclassify F744 as confidential and file the public redacted version of the filing as soon as possible. This concludes my first oral order. I will now issue my second oral order concerning proposals for streamlining the case. I invite the parties and participants to engage in inter partes discussion on ways to streamline the case before 13 May 2022. I order that proposals of the parties be filed by 20 May 2022. Such proposals shall include, but are not limited to, the number of witnesses to be called, the mode of testimony to be employed, the use of written evidence and bar table motions, and time limits for the presentation of the parties' cases and/or for the questioning of witnesses. This concludes my second oral order. I will now issue a third oral order on the disclosure of Rule 103 material. Mindful that disclosure of Rule 103 material is an ongoing and a continuous process, I nevertheless order the SPO by 20 May 2022 to complete its review of the 2,500 items remaining to be assigned for exculpatory review and disclose the material found to be exculpatory. This concludes my third oral order. And this concludes today's hearing. As usual, I thank the parties and participants for their attendance. I thank the interpreters, stenographer, security personnel, and AV technician for their assistance. The hearing is adjourned.
All rise.